morning, everyone. I would like to welcome you to the May 19th, 2009 meeting of the Calaveras County Board of Supervisors. Would you please rise and join me in the pledge? I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation under God, indivisible, with liberty and justice for all. Okay, I would like to read the following announcements. There were 2 closed sessions held last week pursuant to Government Code Section 54957.9, a conference with legal counsel regarding existing litigation, Oakdale Irrigation District et al. Versus the County of Calaveras et al., Calaveras Superior Court case number 35081, and also the Committee to Save Lake Tulloch versus the County of Calaveras et al. That case is number 35086, resulting in no action taken. There is an addendum to the agenda this morning, classifying as 8A. This is a discussion and possible action granting a tentative approval for an agreement to transfer land to the Administrative Office of the Courts for the courthouse construction. Okay. With those announcements, I would like to turn your attention to the consent agenda. As you know, the consent items are expected to be routine and non-controversial. However, anyone in the audience or any member of the board can remove an item for individual consideration. So do I have anyone on the board wishing to remove an item? Anyone in the audience? Okay, if not, the Chair entertains a motion on approval.
Second.
Okay, moved and seconded to approve items 1 through 4 on the consent agenda. All in favor say aye.
Aye.
Aye. Opposed? There are none, so the motion passes on a 5-0. We will be in recess for about 7 minutes, waiting for 9:10 for public comments. We have come to the public comments portion of this meeting, so I'd like to remind you that anyone making public comments this morning is limited generally to a 5-minute per person, 15 minutes per topic. Is there anyone wishing? Good morning, Leslie.
Good morning, Mr. Chair, honorable members of the board. Leslie Davis, acting assessor. I'm back here today to talk to you for a minute about the property tax reassessment issue. We learned on Sunday that additional people have been sending money to this firm in Los Angeles, and we wanted to let you know. We'll be issuing a press release, but we wanted to let you know so you could help get the word out. But on May 12th, Attorney General Jerry Brown filed suit against the owners of the company, alleging a number of felonies in violation of the Business and Professions Act and the Civil Code. And in their press release, they said, among other things, that they made and continue to make untrue and misleading statements. I think that's probably the most important thing for everybody to remember. They're also being charged with 20 felony counts for criminal conduct, and the Attorney General has a claim form on their website that homeowners can use to contact the Attorney General's office and let them know that they have been bilked, for lack of a better word, out of the $179. What's most alarming to me in the complaint that was filed in San Diego County is that beyond the comment that it's misleading, deceptive, and violates California law, is that in many instances they did not perform any services on behalf of the consumers who paid. So it's really important for us to get the word out to property owners that they not submit those dollars to that firm. They can certainly call our office free of charge to request a review. Along those lines, I'd let you know that we have now identified over 1/3 of the assessment roll that we'll be reviewing for this year. We're working with tech services right now to create a website where a property owner can log on and either put in their parcel number, their address, and see whether or not theirs is one of the over 15,000 properties that we'll be reviewing. don't know that we'll have it done in time for the end of this roll year. We're hopeful. Certainly Tech Services is working with us very well to that end.
Let's see, it's going to be for the 09-010?
What we call 2009, what you refer to in terms of fiscal year, yes.
Okay, and when will that be on a website?
We're working with Tech Services right now. I do not have an answer to that question. I'm hopeful that we'll have it up and running within a week or two because we're piggybacking on another query that we use to get property tax information, so that it should be a simple matter of writing the code.
Could you just email us and let us know? I think that's a great idea. Thank you.
You said that in many instances the firm didn't do any follow-up or didn't do any work for the monies expended. Are you aware of any particular instance where they did do any submitting?
I am not. That is a claim that is in the complaint for injunction, civil penalties, and other relief filed by the State Attorney General. I'm not aware of their acting on behalf of any owner in Calaveras County. We certainly haven't had contact with that firm other than them offering me a job.
Seems like it's very much a kind of a predator organization.
It is alarming to us. It's alarming that people are falling for it, and I think that's the basis of this particular complaint, that it's misleading, and people who receive the letter seem to believe that it's a bill from government, and it is not.
Any other questions for Ms. Davis? Thank you very much. Looks like we have a singing group in the back of the room. So.
It's not a song, it's a fashion statement.
We just wanted to remind everyone that the polls are open until 8 o'clock tonight, and we are ready to count everybody's votes. Besides the fact that Carol didn't want to be in here all alone with her teacher. Okay?
Who you famous for the song?
Yes.
You don't need help tonight?
I don't think so.
Okay.
Check with me later, but I think we're good right now.
I'll be here tonight for till 7.
Okay. I think we're good though right at the moment.
Very flashy fashion statement here this morning.
I said if I had walked up here, they were walking with me. So.
Did Secretary of State buy those shirts for you?
No, we bought them personally ourselves.
Thank you.
I can see that one of those shirts on the wall and one of those like a Joe Montana jersey.
Okay. We'll go back to work now.
Very nice.
I know.
Good morning, Mr. Ballard.
Good morning. How are you? I'm here for the May update, Volume 3 for the jail project. I handed you some handouts earlier. Despite everything that's going on, we are making progress. A couple things I want to point out. We did slip 18 days on the schedule, but we were able to recover from roughly about 50 days worth of slipping with PSA Dewberry. And after we got all the contracts hammered out, they were amenable in helping us make up those days in planning and design and those types of things. But I don't know if we'll be able to make up the 19 days. Additionally, we did finally, County Council did finally hammer out the contract with NGL, and they did start yesterday. LAFCO had their board meeting last night and did approve the annexation, so we're moving forward. If you have any questions, I'll answer them.
Eddie, I have one question.
Certainly.
On the project budget, here it says original project budget $56,954,639. And then it says encumbered to date $2,781,483. Have we not encumbered the sanitary district for $2 million, Kitchell's contract, and the contract for Dewberry?
Right. What this reflects here, and you have to pardon me, I'm a week late in presenting this to you. It does not reflect the Dewberry contract yet. This has not been put on there. We haven't got our first invoice. We have encumbered them. We will get this caught up and put on there, but you are correct. Those things need to be addressed.
Okay.
Any other questions? Anyone in the audience want to comment or ask any questions about this Volume 3 of the Adult Detention Facility update? Okay.
One thing, thank you very much.
Yeah.
Okay. Thank you. Okay.
Anyone else wishing to make any comments under the public comment section? Good morning.
Morning, Chairman, members of the board. My name is Mitch Pyle, and I am here this morning representing a newly formed group in the county. It's called the Calaveras County Water and Wastewater Technical Advisory Team, and it is a mouthful, so I'll refer to it as the Technical Advisory Team for now. A very brief history on the creation of this group. During the development of the water element, to go into the general plan, we felt the need, after that process was done, to bring all the agencies, water and wastewater, together to keep, providing resources and advice to the county on those issues. So I brought a copy for each of you guys. And if I could, I'll just really quickly read the mission of the team and general principles. It is the mission of Calaveras County Water and Wastewater Technical Advisory Team to work with Calaveras County in providing education, research, and advice on any water or wastewater related issues within the county. The technical advisory team will work to ensure open lines of communication between agencies, Calaveras County, and the public for the purpose of better serving the water and wastewater needs of all. So in there is contact information, and we have an open invitation for all of you and the public. If they are interested, they can contact whomever their service provider is, and they'll be able to give them information on the agenda, meeting location, and such. And that's all I have.
Anyone have any questions, Mitch? Yes.
One question. On the wastewater, have you all considered asking the septic installers, maybe the septic engineers, to be part of the group?
To date, we've had actually very good and productive participation from 10 of the agencies within the county. So we've only had 3 meetings so far, so we're really kind of just getting the ball rolling. But we're open to, that's what...
I can't address the rest of the county, but
right.
Throughout the county, septic systems are an integral part of our wastewater.
Right. And those are issues that we want to provide the technical expertise to, come up with solutions to deal with stuff.
I like the way you shortcut your
the C
title.
squared, W
very
squared.
Good,
well,
very creative.
If nothing else, we have the longest acronym in the county, I think.
Yeah, very good.
So it's a mouthful, but
very good.
So an open invitation to all of you and the public. And
Thank you.
Unless anybody has questions.
Supervisor Walensky.
Somewhat along the lines of Maria's question, but in another direction, I'm wondering whether you've done any outreach to the private companies that are providing these services to some of our subdivisions.
Yes, we have. It has not gone out yet, but I've drafted a letter. And it's the goal of the group to invite every small agency, special districts, and whatnot to come and participate in this. So that hasn't gone out yet. That's going to go out. But we've had participation from, 10 from Wallace Community Service Districts to Calaveras County. My own personal opinion is it's great because to date, really, there's been no forum that all of us get together and talk about this stuff, and it's been very productive. But yes, all those little agencies, special districts are invited to.
Any chance this group will be talking about developing economies of scale, joint operations, maybe even occasional merging of interest?
Not right now. I gave an example of one of our kind of pilot projects in this packet, which is a shared resource program, and that's to try and limit the outsourcing and subcontracting. I mean, we have a ton of assets within the county, and sharing that amongst all the individual agencies is a financial benefit for everybody. So that's one of our projects that's going. But to address that, nothing's come up so far, but it could in the future. So
I'm rooting for you on that.
Okay.
Mitch, I just have one comment that the shared resources, manpower and equipment and stuff like that's a fairly obvious benefit. But one of the things that excited me the most about this is purchasing power for chemicals. We got together and we're looking at a bunch of water treatment plants and sewage plants that we all use the same chemicals, the same pipe, and everybody knows if you go to Costco, purchasing in bulk gets you discounts. So, that kind of fault, once we get that up and going and information from everybody, we can start to looking into purchasing in bulk and consolidating that kind of stuff. So this really has some pretty exciting aspects for me about even standardizing pumps and there's no reason for every district to have standby pumps whenever you could have them housed centrally.
So it's my goal to get a rep from every agency. Put all that stuff on the table, and I think nothing but good's going to come with it. So to date, we've had excellent participation, and I think we're on a good track. So I just wanted to give you guys some info and update everybody.
Okay. Have you? I'm not a speed reader, but it's probably contained in here. Do you have your governance structure? I mean, your chairman, vice chair.
Yes, we. The last meeting adopted our governance guidelines, and that's the second part of the package.
All right.
And that kind of outlines it.
But due to the fact that you are here and no one else, are you the chair?
I am the representative and spokesman. We have today we have a consensus-based governance structure. If you want to proceed with the project or talk about topics, everybody's got to agree. So I'm the spokesman, and I've been facilitating the meetings to date and organizing the agendas and sending out the information. So, quote unquote, chair, yes.
Well, just from me to you, thank you very much for your efforts, and I'm sure that the board will be wanting to keep tabs on what's going on.
We'll keep you updated.
That's great. Thank you.
That's all I have.
Thank you. All right. Anyone else wishing to bring a public comment forward? Going to give one more opportunity, and then we're going to move on to item number 6. All right. We have item number 6 is a discussion and possible action regarding changes to the assessment appeal process, and this is brought to us again by Leslie Davis.
Good morning, Mr. Chair, honorable members of the board. Leslie Davis, acting assessor. This agenda item deals with 2 issues that we've been facing with assessment appeals, and both of these issues fall under the jurisdiction of the Board of Supervisors. The board, acting in the capacity of the local Board of Equalization, asked that we discuss again the idea of whether or not an assessment appeals board should be created. The creation of an assessment appeals board requires an ordinance. Rather than bring an ordinance to you, we chose to go the route of a discussion with you, providing direction, and that way if we need to write an ordinance, we will. If we don't need to write an ordinance, we will not have wasted the time. We also have an issue around the hearings, the date, the frequency, and the time and place, essentially. I'm going to assume that you've read the package that was provided to you, so I'm not going to stand here and read it to you. I'm just going to hit the highlights for you. As you know, an assessment appeal hearing is an adjudication of a dispute between a property owner and the assessor's office. And the board, acting in the capacity of the local board of equalization, renders a decision either in favor of the applicant sustaining the assessed value or leaving it, or increasing it. You do have the authority to do that. I've never seen that happen in Calaveras County. Recently, we've seen a 5-fold increase in the number of assessment appeals, and that's been causing us a problem in terms of scheduling. Appeals are currently scheduled 4 times a year in the afternoon following a regularly scheduled board meeting. So far in 2009, we've had 2 different hearings go well beyond normal business hours, and that's created over time issues for both the clerk of the board and the assessor's office. We'd like to recommend that you change the meeting day from Tuesday afternoon to Wednesday morning. I logged online, looked at all your office hours, and that doesn't seem to have a conflict. We'd suggest that it be the 3rd Wednesday of the month. We'd suggest that 2 hearing start times be scheduled so that people don't have to sit through an entire schedule of hearings to get to their particular hearing. And we'd suggest that you increase the number of appeal hearings through December of 2010. What I'm not giving you a recommendation on is the creation of an appeals board. As I've mentioned to you, I've worked in counties with an appeals board and in counties with the Board of Supervisors acting as a local board of equalization. And from my standpoint, and certainly the standpoint of the assessor's office, it doesn't change anything. Our staff still spends about 10 staff hours per appeal to prepare, and it wouldn't matter who was hearing that particular application. You do have an alternative to the creation of an appeals board, and that is the appointment of a hearing officer. Under the government code, the board can actually create an office of county hearing officer. That particular individual would need to be someone who was an attorney, having been admitted to practice before the courts for at least 5 years prior to their appointment, or you could contract with the Office of Administrative Law and get a local, I think they call them administrative law judge, to conduct those proceedings. However, those proceedings are limited to issues where the applicant, essentially it's all but single-family properties, and the applicant has to agree to be heard by a hearing officer. In an ordinance that would create the hearing officer concept, the board would need to decide whether the hearing officer's decision was binding or not. In the case of a hearing officer, you can determine that the decision is not binding. In the case of an appeals board, you do not have that authority. If you create an appeals board, their decision is binding, and the only appeal is to Superior Court, similar to a decision made by your board acting as the local board of equalization. So what we'd like to do today is see where the board wants to go in terms of creating or not creating an assessment appeals board, and whether or not we might agree to a change in the hearing schedule so that we can get through the 200-plus appeals that have been filed thus far this year.
Okay. Anyone on the board wishing to ask a question of Ms. Davis?
Leslie, did I understand you to say a hearing officer hears everything but single family?
No. The hearing officer hears essentially single family. The requirement for a hearing officer to be able to conduct the hearing is that the applicant must be the assessee, so it couldn't be someone like property tax reassessment filing on behalf of a property owner. The assessed value of the property can't exceed $500,000, or the property has to be a single-family residence, a condo, or a co-op, or less than 4 units of a multifamily property. And they must require the hearing to be held by a hearing officer.
Got it.
You're saying the applicant can say, no, I do not wish to be heard by a hearing officer.
Correct.
So what's it?
Okay.
And actually, the applicant would have to request to be heard by a hearing officer, not the other way around.
Supervisor Walensky.
I understand that we have a statutory requirement if we were to set up an appeals board that has specific requirements for background and experience, sometimes degrees and et cetera. Could you outline exactly what that is for us?
Certainly. Let me start with the fact that you cannot appoint anyone to an appeals board who has been an employee of any county assessor's office within the last 3 years. So someone who moved up from the Bay Area, retired from Alameda County, could not qualify for at least 3 years. However, you are required to appoint someone who has at least 5 years professional experience in California as one of the following. Either an appraiser who's accredited by a nationally recognized professional organization, and that's like the Appraisal Institute I have a designation from, that would fit that guideline. An appraiser who is certified by the Office of Real Estate Appraisers, again, I hold that as well. An appraiser who is certified by the State Board of Equalization, and you'd certainly hope I hold that. A licensed real estate broker, a certified public accountant, an attorney, or a person that the board believes to be qualified to be able to conduct the hearing.
So how many members are on the board?
You could appoint 3 members or 5 members, but at any given time, only 3 would serve as a panel. So a quorum for an appeals board is 2 members appearing. And 2 board members, Board of Supervisors members who have served in the capacity of a Board of Equalization member are also qualified for appointment. The term is 3 years. Your board has no authority to limit the term, but you do have the authority to not reappoint someone. The law requires that if you start someone on a term of office, their term begins the first Monday in September. So we have the time to come back to you with an ordinance. We should also discuss the financial implications. There's not a lot of money involved, but in every county where there is an appeals board or a hearing officer, they are compensated. The low end of the range is $40 for a half-day hearing, and the high end of the range is $300 for a full day. So depending on the number of hearings, we're estimating that your cost could be about $1,500 to $3,000. And what I didn't add into that, because I'm not certain it would apply, is whether or not there's any employee fringe benefit costs like Medicare that has to be added or anything like that.
Do you know what the current costs of the Planning Commission?
I do not.
Well, it would be 3 members, not 5.
Yes.
I mean, the other 2 members would be basically alternates. Is that what you're saying?
Essentially, the clerk of the board has the authority to pick the 3 who will meet on any given day.
So you can just randomly pick 5.
Randomly, you're pulling 3 for any given day.
But those that would show up and vote at the meeting would be 3 members.
Correct.
Did I hear you say that you could constitute a quorum with 2 members?
Yes.
Well,
2 out of 3 is over a majority.
Okay.
The dilemma with 2 is the opportunity for a 1-1 vote, and then it has to come back. Or actually, no, it doesn't. It depends on the motion.
Okay. Any other questions? Leslie, I have one. There is a statement here that you say that Amador and Tuolumne counties do not have an assessment appeals board. Can you explain how they function?
They function the same way we do. Their Board of Supervisors acts as a local Board of Equalization. Now, there is a provision in the law for what's called a multi-county board. In other words, if Amador County and or Tuolumne County were so inclined, the counties could jointly create an assessment appeals board who would hear items and have jurisdiction over those issues in each of the counties that's involved in the creation of that board. That might help in an instance where someone's attempting to disqualify because of special knowledge. However, this is an appeals board, and the clerk of the board could appoint someone from a different county to serve and get around that disqualification charge.
Okay. Okay, are there any other board questions? I would like to ask if there's anyone in the audience that would like to ask a question of the board or Ms. Davis on this issue.
Looks like it's up to you.
Okay, it's up to us. Who wants to be on the appeals board on Wednesdays? Let me see a showing of hands. Yes. Yeah?
Why don't we talk a little bit about it?
Okay, sure.
It's pretty clear, both from a public point of view, if you have an appeal, you sure don't want an exhausted board at the end of the day, sometimes even late for the occasion. So changing the date at this point, given the volume, makes sense, regardless of what configuration we do. So I certainly support that as an approach, and also having them once a month makes sense because we have way too many appeals to handle on any longer schedule. So those are kind of just adjustments to reality. The other question before us is whether we should be doing this at all as a board. And when I think about what my constituents expect of me, it is generally policy. It's generally dealing with matters that come before the board on a regular basis. Assessment appeals is not, if you were to take a top 20 list of priorities of my constituents, that would not be in it, even on the radar. There's something that does appeal to me in the opportunity to play Robin Hood to your Sheriff of Nottingham, but that is more than offset by practical experience. If this is going to drain this board of one more day per month, and if there's an alternative that could have people who could be specific experts in this complicated area of law, I would support that. It's better for the public. It's better for the functioning of our board.
Do you have any suggestions on how we fit into the high and the low range of compensation, how that would be?
I don't think we've ever been a high-end range county. You can ask anybody who works for us on that. We've got, I think, pretty good planning commissioners, and they're working, I would suggest that it would be roughly the same arrangement.
Okay, and there was mention of the fact in this report that we don't currently have a budget for this, so we'd have to leave it up to Bob and Shirley to find the money for it.
It'd be up to the Board of Supervisors to find the money. It's general fund money.
That's correct.
Gee, I'm almost of the opinion, given the last couple of experiences we've had, of
taking out your wallet,
my way out of this. I'll leave it to others to.
I'll voice my opinion. I do not want to establish an assessment appeals board. We already know during tax season a CPA isn't going to make it to anything. Since a hearing officer seems to be something that's more optional, I just assume that the Board of Supervisors, and the easy out is to do a hearing officer or an appeal board. At some point, maybe in 2 more years or 3, we will hopefully be back to 2 items on the agenda and sometimes 1. And I, for one, would like to just keep it with the Board of Supervisors. And more importantly, I do not want to spend any more money than we have to out of the general fund. I just feel like we can't do that. We can't afford to do it now. What's 3,000? 3,000 here, 500 there, 1,000 there. It all adds up to something we're going to have to deal with at budget time. so I don't support it. And knowing that I have 2 third Wednesdays already booked for the rest of this year, it would be just like the Board of Supervisors. You will need at least 3 of us here for an appeal.
That's correct, and I'm simply throwing out the third Wednesday as an option.
Oh, no, I understand that.
I zeroed in on Wednesday as a day nobody had a recurring event, and I just picked the
Sunday
third.
afternoons work too. Okay, so, my position is I just leave it. I just like to leave it with the board.
I'll voice my opinion. I'm not in favor simply because of the money being expended to general fund at this time. When I was elected and I ran for this job, I knew that part of the job entailed making tough decisions in the public forum, and that was part of it. So I look at it as part of the job. I accept it. And if we were in better times, lean times, certainly I would consider it further, but spending, like Marita said, $3,000 here, $500 here, I don't think we're going to have it in general funds. So I'm willing to go one Wednesday a month to clear up the cases we do have, and if it takes 2 years, then it takes 2 years. If it takes 3, it takes 3.
Supervisor Tryon?
Let me ask one question. If the board were to form an appeals board, as being the board formed it, I guess the board would have the ability to end it if it so chose. Is that correct?
Yes.
Okay, then my feeling at this point is I would support the formation of a 3-member appeals board. I think it's going to be very difficult for the Board of Supervisors because of all the other commitments we have to, basically be meeting on other days that and get 5 board members here. But I guess you don't need 5 board members here either. But I don't look at it as being the cost as being significant. I don't believe we're going to, you need to meet every month. We've been meeting quarterly. You could meet every other month, or even if you just had a quarterly meeting and it's all day long, as opposed to 3 hours in the afternoon. It seems to me to be adequate, and I think the Planning Commission's $50 a meeting. So if you had 3 board members, that's $150 when they meet. If they meet 4 or 5 times a year, and basically have a full day meeting, you're talking $600 or $750, and I think that's better and getting through the workload. What I guess I'm more interested in is getting the workload processed. I don't want to be what happened to the planning department, and nothing gets processed, and all of a sudden we start losing because we're not processing the appeals. I want them processed. And then when, the workload gets to the point where, it's 2 or 3 hours quarterly, then I think, the board can certainly look at bringing it back to the board. But I don't look at it as a financial issue. I look at it as let's get the workload processed. We have a blimp in the workload at this point because of the market economy. It will not last. But I just don't want to get behind on the processing. I think people deserve an answer, and they deserve to have their appeals processed. So at this point, I would be in favor of a 3-member appeals board.
I want to respond to Supervisor Tryon. I'm going to pull a Supervisor Del Ordo thing out of the hat. Once you start something and you set up that process, that bureaucratic process, it isn't going to end. And
you mean like the transit system in COG?
So I just want to remind you, Tom, that, once we set it up, it's just not going to go away in 3 weeks.
I want the workload to get processed, and I realize there's a big limp in the workload. And if we can do something for a couple of years and get that processed until home values quit falling and we stabilize, and once they quit falling and are stabilized, then I think a substantial component of that workload will go away. And, you're talking 3 members. That's a whole different thing than COG or transit. Once you get people put on in a position of dependency on government, it's hard to pull away from that dependency. I don't look at this as putting people in a position of dependency on government. I think the board, if it so desires, can certainly act once the workload issues are resolved and the decline in house prices is addressed, or real estate prices, I guess I should say, to bring it back to the board. I'm not against it.
So and then 5 years, when it takes a nosedive again, you start it back up because of the caseload. So you're going to go on a caseload scenario, creating and uncreating and creating and uncreating.
Well, we've had a lot of business cycles since I've been here, but we've never had one like this for a workload for the assessor's office. So I don't think the normal business cycle puts us where we are today. This has been an extraordinary set of circumstances, and I'm willing to look at it as an extraordinary set of circumstances, and this as a interim solution to that set of circumstances. If I'm here and the workload can be brought back as with an historical workload that we've historically had, I would be voting to bring it back.
Okay, before you make your comment, Supervisor Toffanelli brought up in his discussion or his comments that if it takes 2 years, so be it. If it takes 3 years, so be it. I read in this document that the applicant has a right by statute to get a decision within 2 years. Otherwise, it automatically is made in their favor. Is that not correct?
There's a statute of limitations that the board must hear the appeal within 2 years, where the applicant's opinion becomes the basis of taxes for that event. However, if I could put words in Supervisor Toffanelli's mouth for a moment, what I heard him say was if you were meeting 10 times a month and we were scheduling 20 hearings per meeting, then you would get through your 200, because we all know we have withdrawals and other items coming off the schedule. So I think what he was saying was if you could do 200 hearings a year on this different schedule, that's where he would go. But
that's what I was saying. It had nothing to do with extending the length. If it takes us that long because of the caseload that we have.
And I might tell you that it is the clerk of the board who has the authority to schedule hearings. We work very closely with them. And there's one thing that we do in our office is track to be sure no one's getting past that 2-year deadline. So if we saw that happening, we'd actually be asking the clerk of the board to add more items to the agenda. And then we'd have an internal discussion about how much effort we would put into defending that added workload.
Supervisor Walensky.
Regarding Supervisor Callaway's concern that this might be a thing that we would do in perpetuity, I would suggest as a possible measure that we would do a 2-year, starting in September, pilot and see whether it works. And it would expire unless we took affirmative action on it at that time, 2 years hence.
Okay, I could support that. What I'm still not certain of is the specific structure. We talked about, I think where Marita is having the knee-jerk reaction to the expenses that she's visualizing.
I didn't have a knee-jerk reaction. It was thoughtfully thought out. My knee just hit the...
Are you still contagious?
Don't touch me. Let me rephrase that. Her legitimate concerns about the expense. But if we could have a hybrid organization, just one moment. I certainly would feel like Gary an obligation to make myself available for. We don't have to have the membership does allow a member of the board to sit on this appeals board?
We would craft the ordinance so that you could appoint 2 of your own members to be on the Assessment Appeals Board.
Yes.
However, the clerk of the board is going to pick a 3-member panel at any time to sit. So there would be no guarantee that there would be supervisors actually sitting in every hearing. But that's all part of how the ordinance would be crafted. That's why I'm taking what I hope is copious notes.
Okay, Mr. Lawton, you had a comment?
Yes, Mr. Chair. There may be yet another way to skin the cat or thread the needle. As you know, this board does not hold meetings on the 5th Tuesday of the month. So there are 2 months usually in a year, maybe 3, where there are 5 Tuesdays. There are other boards in the state which go dark on the 4th Tuesday of the month and meet on the 5th Tuesday and have 12 Tuesdays available each year. Your board could choose, rather than create a new structure, to adopt a new schedule. For a limited period of time, you try it for a year, for 2 years, let's say on the 4th Tuesday of the month, rather than sit as the Board of Supervisors, sit as the Board of Equalization. That would enable you not to split your day between one type of activity and another. It might help you clear the backlog. It wouldn't require the creation of a new bureaucracy. It wouldn't add to the weekly workload of the clerk's office, having to add another meeting to their group. And I just put that out there for your consideration. You could always change your schedule fairly easily once the backlog was addressed.
So you're saying we'll have 3 board meetings a month, and then on those months where there's a 5th Tuesday, we'll have 4 board meetings a month?
That's correct, Supervisor.
Those sounded like 2 different comments. One, I thought what I heard you suggest was the 4th Tuesday of the month would be for appeals.
That is exactly what I said.
Or an alternative would be to use the 2 extra 5th Tuesdays.
But yeah, that will do little to avail the board.
I agree.
I think it would be more constructive.
So what you were saying was the 4th Tuesday would always be Board of Equalization. The other 3 Tuesdays would be Board of Supervisors.
Correct. And then the months that had 5 in it, that 5th one would be a Board of Supervisors meeting. Correct?
As the board chooses to do.
So can we test the barometer of that idea? What do you think of that, Supervisor Tryon?
I stick with the 3-member appeals board.
Supervisor Walensky?
I'd like to see an appeals board as well, and with a 2-year sunset clause.
Yes, I support that.
Supervisor Toffanelli?
I'd stay with my original.
Well, so far you're 0 for 3, Bob.
I'll start packing.
I'll stick with my original recommendation.
Okay. All right.
Supervisor Thomas, Chairman Thomas will back you. And
There you go.
All right.
I don't have to sit with the Board of Equalization, so I'm...
Well, I think that this issue sounds like it's going to come down to my opinion on this, and I'm kind of, my memory banks are going back to the long discussion about whether this board should meet on a Monday or a Tuesday, and by golly, we just really wrestled. I wasn't on the board at that time, but we wrestled with that, and there was, I think, some beneficial results out of making that huge step to change from Monday to Tuesday. So change the operation, change the procedure. So I'm going to support the creation of the appeals board too. So
May I clarify, your initial comments were to support it with a 2-year sunset?
Yes.
And there are 2 other board members leaning in that direction.
Yes.
So when we bring the ordinance back, then we'll bring it back with a sunset date.
Okay.
Could I also see how people feel about the other matters before us? We have a question of how many appointments to make, and this would be a 3-person panel, but would we want a pool of 5?
We would recommend that you appoint 5 so that 3 can be.
So is that okay with you? Okay. And then the question of what we do between now and September. is also up for our recommendation.
And I have no problem now expressing an opinion now that you've made a decision on whether or not to do an appeals board. There's a 45-day noticing requirement for all hearings. We've already talked, and we already have July on our schedule. So by June 1st, the clerk of the board would be sending notices out for your July hearing. The question would be whether or not you want to also meet in August, because the code says that the term starts the first Monday of September. We could certainly write it so they start sooner. I would just, if I could whine for a moment, it's budget, it's close to the roll. We're going to have a lot to get back to you. We may not have it done so that you have appointments after you recruit for these people. So I would suggest that you go ahead and have a hearing in August as the Board of Equalization, and then in September start the appeals board.
Okay.
All right. And then the only other thing before us is the question of whether to continue to try to do this on Tuesdays or whether to move it to a Wednesday or alternative
Well, with
full day.
an appeals board, it would have to be something other than Tuesday.
Well, no, I'm talking about between now and when the appeals board takes place. And so what would our protocol be between now and then? My recommendation would be that we move to a separate day just for that period. Although it's an inconvenience, it is too voluminous to handle.
You could throw the CAO a bone and do it on the fourth Tuesday for those 2 months.
Not my time. Well, there's five Tuesdays in August.
No, there's not.
No, there's not. Excuse me. That's a Monday.
We could go back to Mondays.
But there is 5 Tuesdays in June.
We would recommend strongly against June. We're trying to close an assessment.
Right, yeah, that's not.
I'd just schedule it on a Tuesday at this point.
Normal schedule?
Yeah.
Okay.
Okay, well, I would
We
like
have
to...
2 years to get things done, and we're not pushing a 2-year deadline, are we?
No, not that I'm
Well,
aware
then
of.
let the board handle it in September, and we'll take care of those things that you want to get scheduled in July and August.
So we'll work with council and come back to you with a recommendation for an ordinance to appoint an assessment appeals board and everything that follows from that. Anything else you want to change, Wallen?
Point of order here. We have expressed our opinions, but I would like to formalize this with a motion and a second and a vote, if we could, please.
Can we do that in relation to this agenda?
You're really not taking any final action.
No, we're just giving her direction to come back with the ordinance.
Yeah, I think you've done that.
We've done that. All right. Okay. There was grousing up here about we didn't vote on it, but I guess we did de facto.
Excuse me, was the issue of asking questions of Ms. Davis, was that public comment? I didn't hear the term public comment being offered.
Mr. Kelly, maybe my command of the English language has forsaken me this morning, but I did ask if board members or any member of the public wish to ask questions of Ms. Davis.
Yes,
do you
sir. I
wish?
didn't have questions for Ms. Davis. Well, I did, but I also had statements to make. And public comment should be referred to as that under the Brown Act, I believe, not coming up with some other way to massage your way into going back to the board. It should be literally spoken, that public comment, and then returning it to the board so that the people in the audience know what's happening.
The Brown Act actually requires that you provide an opportunity for the public to address the board on issues. It doesn't use the term public comment, but it's academic. The point is that the public does have an opportunity to address an issue.
Okay. County Council, can you provide me with an opinion here? Did I or did I not ask for anybody's opportunity? I gave everybody an opportunity to ask questions or make comments. Did I not?
I think the opportunity to address the board on this issue has been met.
Okay. All right.
I wish to address the board too, and I feel the same as him. When you ask comments to her, I have comments to make. Also, but not to Ms. Davis.
Well,
so I felt the same way. When you asked that, I had no comments to make for her, but I didn't have comments to make about her.
all right. Your point is well taken. Mr. Kelly, the chair recognizes you. I'll give you 5 minutes.
Thank you, sir. The financing discussion included conduct of meeting. I suggest adopting the California Board of Equalization's outline of assessment appeals hearing, and the Assessment Appeal Training Manual, and the Assessment Appeals Board Member Training Legal Issues Manual, so that things can be in a very much consistent way here. These things would cover the issues to guarantee due process consideration. The adoption of these procedures will provide uniformity, consistency, and a State Board of Equalization website with Assessment Appeals Manual information, property tax rules, assessors' handbooks, and other information for the applications. And by the way, Joe Kelly, thank you. Additional cost for mandatory training. Why? Is the Calaveras County Board of Equalization required or encouraged by the State Board of Equalization to attend training? Is mandatory training a requirement for an assessment appeals board? Currently, doesn't the interim assessor provide training? What would change? The discussion of assessment appeals board selection, eligibility requirements, and mandatory training requirements differ from Calaveras County Board of Equalization. Supervisors by law are the local Board of Equalization. The two positions are distinctly different. Board of Equalization members are not required to be knowledgeable in property taxation. Board of Equalization members are not required to attend property taxation training seminars. Calaveras County Board of Equalization members are encouraged by the State Board of Equalization to attend a training seminar to keep abreast of important changes in property tax laws. I support the creation of a 3-member, 2 alternates assessment appeals board without Calaveras County Board of Equalization members' participation. A totally separate board without color of authority influence from any elected official, appointed official, acting official, or county employee. Consider the potential for non-recusal by a Calaveras County Board of Equalization member due to a meeting with a constituent during a Board of Supervisors office hours. A Calaveras County Board of Equalization member is not supposed to have any knowledge of the property or ex parte communication with a property owner prior to the commencement of a hearing. Personally, I believe the Board of Supervisors' assistance to constituents through office hours and site visits are more important to the welfare of the citizens of the county. And then with respect to setting a 9 a.m. to 10:30 a.m., 10:30 a.m. to noon, 10 applications per hearing, that equates to 9 minutes per hearing. That means the Board of Equalization would have to be there on time. Are you guaranteeing complete due process or invoking a wait and see who sues attitude? Now, in respects, February 24th, 2009, you had 7 withdrawn applications, 17 open applications, 8 were rejected for lack of appearance, 4 were for continuance, and 3 heard. April 28, 2009, 9 withdrawn applications, 13 open applications, 5 lack of appearance, 2 continuances, 6 heard. Thank you.
Thank you, Mr. Clapp.
Anyway, I would encourage, which part of you guys are going to do is for the board to do the pay, because I was
come from Fieldstone. Fieldstone has been built out and it's been sold. I don't think you can go back to those people and say, come on, cough up the money, $15,000 or whatever it is. There was certain requirements that I think the county basically put conditions of approval. They allowed the projects to go forward without airing dirty laundry. There are some problems, I believe. You're talking over $500,000 right there. There's also a condition that was placed upon Creekview Subdivision and Stone Ridge Estates that said these are the fees you will pay. You will pay $4,017.26 per lot. Made no mention of that unless the benefit basin changes, then you will pay an increased fee. It said this is the fee you will pay for that obligation. I noticed in the report it's kicked up to a much higher figure. Jack Couts has already taken out building permits and constructed and sold 15 of the 33 homes in Willow Creek Cottages. The fee schedule that's in the adopted benefit basin says, no, we're going to get a lot more money out of those. Well, how do you get them? They've already been sold to a second party. They own the home now. Are you going to try to go to them and say, come on, cough up the money. We need it to build the roads? There are some other issues. This is not the appropriate place. I realize that's not why you're here today. You want to extend it, and I can understand that, and I fully expect that. I just think there are some serious issues with this, and I would hope that you would work with us to try to resolve these issues. And I realize the implication of this means that the fees, and I already ran some rough numbers, instead of paying the round number of $15,000, the people will probably be expected to pay $23,000 per connection. And as Mr. Segala said, pretty soon you get the fees up to a point where you don't get the money, all you do is stop development. So I would like, again, I'd like to request that we get a meeting set up with the appropriate people at the county level and my client and myself to sit down and discuss this, where we can hammer out some of these issues, because I can tell you with that much money on the line, if an agreement can't be made, in all probability it'll end up in the courts. Thank you.
Gene, I have no problem with such a meeting, but just for some clarity, and it's my understanding that Jack, when he did those earlier developments, had an obligation to update the benefit basin fees at that time, and basically did not, and requested that he do it when later developments were done. So I think that's clearly the obligation of the developer.
Okay.
Is my understanding. I was not a party to those deliberations, but there was a considerable amount of obligation that was rolled forward into the new developments.
I've never seen paperwork to substantiate that.
I'm very happy to have the meeting. Quite frankly, I don't know how it would affect Jack, since it's that would basically come out of Jack's reimbursement. So it's going to be probably mostly his money anyway. But if you'd like to have a meeting, then that's fine.
Yeah, but the impact it would have is and I agree with you, because truthfully I don't think he's going to get any money out of this. But the effect it has is that it will take all of those undeveloped lots, and you're going to see the fee go much higher than what you've already adopted. And that's why I think we need to have the meeting, and so this can be discussed.
Well, I guess staff would have to go back to the development agreements with the developer when some of these obligations were rolled forward.
Right. Okay. Thank you.
I think if you do this, because you have other properties in Russ's thing, Rancho was approved by the county, assigned by the clerk, and it became a subdivision. You're still charging fees on those lots. I have lots. I pay more property taxes than homes are paying in there. But I don't have it's an empty lot. But I'll be in the same boat when I build that house. I'm going to have to pay the fees at that point too, and I have on some already. And that lot was approved by the state, and all the mitigation fees and stuff was considered. And that lot was developed and approved and signed by this law. It's a contractual right that I have on all those lots. And so you're changing the rules there. So I don't. You just got like a whole bunch of worms here. I don't know what you guys are going to do.
I don't think we need to introduce Rancho Calaveras into this.
That was what we were trying to avoid.
Okay. Anyone else wishing to make a comment on this?
Mr. Chair, just to point out that the item on the agenda is limited to the extension of the urgency measure. And again, I said it before, the term urgency and emergency are sometimes used interchangeably. It doesn't qualify for an emergency, but as an urgency measure, which just requires a finding that it's done for the public welfare, is the basis of the urgency measure.
But I made a note here that when Rob Houghton first addressed this, he said that there are some timing issues that are also an adjunct of this decision. But these two building permits, how do we, or the two properties that have pending building permits in the hopper, how do we charge them? How do we address them? Isn't that part of what we're talking about here?
The only item before us today is extension of the urgency measure. If the board chooses to make changes to the implementation plan, chooses to make changes to how we set and calculate fees, Public Works would have to come back to you with modifications to the implementation plan and the fee schedule to reflect that. So we were just seeking direction from the board on that particular issue rather than a formal decision today. And if this would be appropriate, I could respond to the issues that were raised during the public hearing. I don't know if that's closed yet.
Public hearing is still open. Go ahead.
One of the, I guess let me tackle the what seemed like the biggest obstacle first, and that was Mr. Deaver's concerns about fundamental flaws with the benefit base. And to my understanding, every one of the issues that he raised has been raised previously over the course of several years, and I think are clearly addressed in the technical report that was prepared to support the adoption of the benefit basin update. And I think it should also be made quite clear that neither Fieldstone, nor Stone Ridge, nor Willow Creek have paid a penny in benefit basin fees to date. So when he's complaining about not being held to his fee schedule of $144,000, I believe is what it was for those two developments, Willow Creek and Stone Ridge, he has not paid those fees. In lieu of paying those fees, we are preparing a credit reimbursement agreement that will consider all of his development within the benefit basin and for which certainly holds a significant fair share of the traffic and attributable cost to the benefit basin. So I think clearly an equity issue, I think we're in good standing here. And I think technically the technical report addresses the issues that he raised, identifies the provisions within his development agreements that hold him subject to the benefit basin and appropriate follow-through. Certainly, I'm quite open to meeting with him to further discuss those issues. I would encourage him to review the technical report and argue some of the particulars within that. With regard to non-connector roads or residential roads being put into the benefit basin and for which other folks are being levied an assessment for, all of the roads that are included in the benefit basin and for which these fees attempt to recover the costs of are strictly connector roads. And to that end, encroachments were limited on those roads. There are very few residential encroachments on those roads simply to protect them as connector roads. And in the course of developing Couch's maps for those subdivisions, he was forced to remove encroachments from those roads and restructure his road system in order to make those connector roads work as connector roads. So I think they truly belong in the benefit basin, and no one is outside of those subdivisions is being asked to pay for quote-unquote residential roads. With regard to fees previously paid, we've done what I believe to be exhaustive research on fees paid in the Bret Harte benefit basin. And it is a somewhat tortured history that goes back literally decades. And what we found, ultimately, I think we've got a clear line of documentation for fees paid. And anybody who literally paid benefit basin fees in the past has been clearly documented. That would be the Meritage Estates and Indian Rock Phase 1. And those folks have been credited, and so those parcels will not be subject to benefit basin fees. The one subdivision that was less clear was a Golden Acres subdivision that paid GRIF fees before the benefit basin existed. It's a general roadway improvement fee that was placed on it was a requirement placed on the tentative map when Golden Acres was originally subdivided. I believe it was late 80s, so before the Bret Harte benefit basin. And those GRIF fees that were paid have been credited to the fees that will be assessed to those properties when they pull a building permit. I think if I've caught everything, I believe those are the comments that I heard, and I hope those addressed those comments.
So when you pull a building permit, whatever the benefit basin fee is will be subtracted the GRIP fee.
Correct.
Okay. I have one other question. Either Tom or you might have an answer. It's like when the benefit basin was established and everybody was kumbaya-ing and very excited at the time, and then we went to the down zoning.
That couldn't have been Tom you were talking about.
I've never heard him say
In the down zone from the commercial to the residential. Remember that? Because the benefit basin fee had been set up with what the zoning was at the time.
Mm-hmm.
So
that was the Golden Acres subdivision, yes.
Okay, so did they wind up having to pay what the original zoning was versus the down zoning?
Yes, they did.
Okay.
Because, and the reason is
for the whole
you
reason.
couldn't pass the environmental review for a zone change because of traffic if you didn't pay the fee, because the fee was based on the needs to complete the basin as it was envisioned at that time. So then there would be a gap, and so in order to meet the environmental review for a zone change, you had to meet the full obligation that had been assigned to that property based on the traffic that would be generated by the zoning in place.
All right. If there's no one else that wishes to address the board on this, I'm going to close the public hearing. And
Mr. Chair, I would move that we act on what's before us, which is an extension of the interim authority for the Bret Harte benefit basin, which is the extension of the urgency measure for another 30 days.
I'll second.
Okay, moved and seconded. All in favor of that?
What? We can have discussion?
I think that we're compelled to have discussion. Go ahead.
My knee-jerk reaction is, well, I'm just trying to organize, excuse me. I remember how really sort of progressive it was considered to establish the benefit basin, because everybody who wanted to build in that area knew they couldn't build in the area till some infrastructure was put in. So I think, if we go back to that point in time, we understand how positive a benefit basin is. I'll support the urgency ordinance, but I also feel like Mr. Hereford and Mr. Lee should be given the due consideration. And I've already told Tom and received his wrath. But the reason I'm doing it, and this is really a lesson for staff and for this Board of Supervisors, if we do not keep fees, benefit basin fees, and WIM fees current, which goes to, we hate to raise fees, Board of Supervisors, then we're going to be stuck in this position in another 3 years, 5 years, or 10 years. It really needs to be prudent on us. We're now stuck with a WIM issue where we're going to have to go out for a vote. We don't want to raise the WIM fees. We don't want to raise the benefit basin fees, and now we're stuck on a quagmire. And I think in consideration of the fact that we haven't done our due diligence over the years, which we should have, and gotten upset when the realtors and the developers come in and how can you raise it? You're going to kill development in the county, and then we just go ahead and do it. Then we're not in this difficult situation that we're in now. So due to what I think is a lack of action on our part over the years, I would support the 2 parcels for Lee and Hereford staying under the old fee structure, period. That's it. I also want to address the comment that we hear all the time about, well, if fees go up, we're going to stop development. Well, if we didn't have a benefit basin, there would have been no development in the Bret Harte benefit basin. So you can't have it both ways. We cannot ask the taxpayers of Calaveras County to subsidize the infrastructure for development, and that's really what we're going to be asking for if we say the fees don't go up. So we can't, if we're going to stop, development will stop anyway because we do not have the infrastructure to support the development. So we can't keep going around on this circle saying, oh, you can't raise the fees because you're going to stop development. Well, we won't raise the fees, and we're in the quagmire that we're in today. So fees are part of development. It's expensive to develop, and I'm hoping that when we look at the Copper and Valley Springs benefit basins, that we have the courage to do what is necessary to make those come to fruition, and we don't get stuck with what we have here with Bret Harte or with the Rim. So that's my platform for the morning.
Anybody else wish to make a comment before we ask for the vote? Before I ask for the vote.
In front of us.
Supervisor Walensky.
Well, before we beat ourselves up overly much, I think it's important to note that this was properly arranged to begin with, and it was forward-thinking, and it was the right, I think the right metrics and calculations for a different way in. And Caltrans bears at least some responsibility for our current predicament. I also think at some point we have to take a look at what the value of a project is, and everybody has some, despite ourselves to some extent, we've managed to create value in a situation that was where people were able to share the cost. What that cost is did change dramatically, and now we're faced with the question of what's a fair allocation of the new cost. People who got in early appear to have wound up with a great deal, but the question is how much you back up, how many people get through that door until it's the last, we're back to where we started, which is you take care of the whole thing just by accident of timing. That's the whole benefit basin was designed to share it as broadly as possible. Truthfully, we're not going to have a good choice here, but my hope would be, and this is just my forlorn mediation instincts here, but I would think that there'd be something between the current points along the lines of something in between the top cost and the getting the original amount that's being proposed based on interim timing. People caught in twixt the twain, and I don't know whether there are going to be other adjustments based on the discussions that might happen that Tom's agreeing to, but I would hope that something that people could work out a reasonable agreement that keeps the principles of a benefit basin alive. I don't know what that looks like. I got no dog in the fight over there. And I'd make one other note that this is something unique to this district. And this district supervisor is elected to represent that interest, and just on a jurisdictional basis without broader principles, I would support this across the board. Certainly in this tiny thing before us, I'm supportive of it.
Okay, and that supervisor has a motion and it has a second. And okay, unless I hear further discussion, I'm going to ask for the question on the motion. All in favor say aye.
Aye.
Aye. Opposed? The motion carries on a 5-0. And then for a recess.
Can I ask a question of clarification? I mean, since I voiced support about the 2 parcels in question on Mr. Packinger's memo. How is that going to be dealt with? Because that was not the issue before us today.
We would have to come back to the board and make the adjustment to the fee that was adopted approximately 30 days ago.
Let's see if there's board support to do that before. I mean, that's Marita's position. It's not mine. So maybe you should pull the board and see if there's support to do that.
Okay, I'm willing.
Another burden.
I'm willing to do that, but I just want to make sure that my understanding. I mean, I've been at the counter over at the former CDA and watch people submit the plans and the fee calculation. All fees are due upon application for the building permit, not when you go in and pick it up. You pay in advance. So, I mean, this is like, to me, this is very much like the post office offers you the opportunity to buy a forever stamp. And I bought a whole book of forever stamps, and then all of a sudden the post office or this board is saying, oh, well, we didn't, that didn't apply anymore. You need to add more postage. That's fundamentally wrong in my mind. So I'm going to officially poll the board, and I've stated my position. We've heard Marita's position. However, Marita, you were saying on specific parcels. I am not inclined to agree with Mr. Hereford's request that the old fees apply to the 2 phases on one parcel. You get you cross that line that we allow the old fees when you apply for a building permit. And were you inclined to say that you want to extend that privilege to a portion of you want to really? Okay.
To the whole phase 1, phase 2.
To the whole APN.
That's a stretch for me. Supervisor Toffanelli, how do you feel on this?
I'm in agreement with Supervisor Tryon in his position. I don't know what's going on with phase 2. I don't, if it's all one APN and it's not being built out, he hasn't applied for permit for the whole thing.
But how do you feel about the permit that we have 2 builders, developers that have applied for the permits? They're in process. I mean, it seems to me that the background information that I've seen, that it's conceivable that things move more quickly. I mean, it's just like
I think we've drawn a line, and the line is when you get the permit, you pay the fees. There's been a line drawn. You have to draw a line somewhere.
Okay. Supervisor Walensky.
Well, I really hope people will go out, talk about it, come back with a consensus agreement that compromises this, and we're all happy. But that's not going to happen, it looks like. and I'd be an outlier in this vote, rendering it 2-2. So I'm going with the notion that this is a in-district issue. There's not a large principle besides the one just outlined by Supervisor Toffanelli, which is that we have been, if we're to apply that principle you just talked about, we would wind up with all kinds of problems with the set of fees we just raised. We've been trying to apply the building permit, when you take your permit out, standard for quite a few things, and I'd hate to switch that.
Let me give one more recommend to the board. When we did that you had to be on water and sewer, we agreed to look at items case by case. And we made that
That's right.
a starting right now issue. So we have a case by case issue. Right now we have 2 cases. In the water and sewer, we have I don't know, maybe less than half a dozen, 4 or 5 cases that came before us. To me, this is the same thing. When you do something starting immediately, like we did that, and we're doing this, then something's going to fall through the cracks or get caught in that vine, and the courtesy should be given to those cases that are caught. And to me, these are 2 that are caught in that quagmire, and we should honor that like we did with You Must Be on Water and Sewer.
Well, let me see if I'm reading you correctly here. What we said was not that we would, at the time of that consideration, what we said we'd set forward a process that we would consider those one at a time. Right now, today, what's before us is simply this extension. Are you suggesting a process similar to the other one for these 2?
Yeah,
but your proposal, at least last enunciated, was that we wanted to simply go ahead and instruct to both parcels.
Well, Mr. Packinger said, you tell me what it is you want to do, and Russ is polling us as a board. And I'm just using the analogy of water and sewer to this case. When the board, says effective immediately, this is going to occur, we know there's going to be some cases that are not going to be fall on one side or the other and be real clear. These 2 are examples of that, and I think we need to give that the courtesy it's due.
Well, I don't think that's exactly correct. While we had the meeting at Ironstone, indicated there was only one person who had, at that point, applied for a building permit, as I understand it, and that was Dennis Lee. And Dennis hasn't shown up at any of these meetings, but as I recall, and somebody correct me if they recall differently, but Dennis's feelings were, I don't mind paying the new fee, just tell me what it is, and for God's sakes, don't hold up my building permit. So I think he went over and just basically agreed to I don't know if he's paid them yet, but basically agreed to pay the new fees if the building department would just issue his building permit so he could proceed with his construction. I think Jim's permit, at least as I understand it, and I think he put it in the record 30 days ago, was applied for after that meeting at Ironstone. I think it was in the public record, and I stand to be corrected if I'm in error here, but he indicated he had applied for the permit, I think, a week and a half prior to the adoption of the first emergency ordinance, which was considerably after the meeting. Public Works at the meeting had stated, with my support, that we would go ahead and process building permits, but they wouldn't be issued until the new fees were addressed by the board. And if the board, supported the new fees and passed an urgency ordinance, then those would be the new fees. So. That's why we're here, and that's why we went with the emergency ordinance.
Okay, Supervisor Callaway, the case-by-case consideration that you have alluded to, do you visualize that being beyond what we're doing here today? Do you want to bring...
We now only have one case since Mr. Lee's taken care of. And,
well, I mean, if you do it for Jim, you're going to have to do it for Dennis. His was in prior to Jim.
Well, that's what I said.
Okay, but I'm just saying that Dennis's position wasn't that he didn't want to pay the fees. He didn't speak strongly. I mean, he'd rather not, Dennis, obviously. Who wants to pay
the new fees? If Dennis doesn't have a problem, let him pay the new fees.
Well, obviously he would rather not. So that's not a fair characterization.
I mean, Tom, this project was in for review, plan check, everything. If the issue is that, I think Gary brought it up, that people pay the fees at application time versus permit time, you could have 2 weeks or 2 months in that period, and the board can make a lot of decisions in that time. You'll have an application that comes in, and when it gets to permit time, it could change. So if the board wants to collect fees at permit time, then we need to say we will collect all fees at permit time.
Permit application?
Thank you. At application time. And then if the permit isn't quite the same as the application and you do a refund, you get it. And if it's more, it's more.
There are other instances where the board has basically said, particularly on planning fees, where we said, we're going to revise the fees, but we want to go ahead and continue with processing the application. And that's basically what was stated at Ironstone, that go ahead, we don't want to hold up anybody's application. We can process that and then take the urgency ordinance to the board. And that's basically what happened. And the simple reality is, as I said before, somebody has to pay for this. So you put it on other people, or do you put it on all those that have not yet obtained a building permit? This basin, is basically everything the environmentalists advocate, and quite
and
frankly,
we thank you, Tom.
Well, let me finish, Maria. And something that I also support in the sense that we have very intense development, and we have density, and we have everything that we want. And for God's sakes, we can't end up with having deficient roads in this benefit basin. It's in the heart of Murphy's, and we need to have high-quality roads along with the other infrastructure. And when Rob showed a slide, I believe it was Rob that showed the slide 30 days ago, or 29 days ago, whatever the heck it is. He showed the walking paths, et cetera, to be constructed along Bret Harte Drive, and they're high-quality walking paths. We've made sure that we have good pedestrian and sort of bicycle circulation within the benefit basin. We've tried to have sort of upgrades and all the infrastructure that you would like in a basin where we're encouraging fairly high-density development. So, the last thing I'm interested in is having this be finished and having deficient roads in the basin with inadequate pedestrian and bicycle paths. So, we've asked the board to be polled. I think we should finish the poll.
Okay, the way I'm keeping track of this is that Supervisor Callaway and I are in favor of giving the benefit of the early application, the fees to the early application. Supervisor Toffanelli, I think you said otherwise.
Otherwise.
Okay. We know how Supervisor Tryon feels, where it's in your hands. Supervisor Walensky.
You already said how.
I said I wanted to go back and talk about it and come back with a consensus.
But he support the supervisor.
But having failed to get a second for that concept, and even seeing differences between your two approaches, one of which is to grant the first days separately from the second, and yours is to grant both, I don't even see two consistent votes on that.
So, wait a minute. I'll negotiate with you, Mr.
I've been hinting for a while. I'm done. I'll vote with these two, and it's 3-2.
Okay. I've been on the short end of those polls before, so I'm sorry. I guess the consensus of this board or the polling has indicated that everybody will pay the new fees, even those of us who thought we were buying a forever stamp. So, anyway, I think this concludes our discussion on item number 7. Going on to item number 8.
Mr. Chairman, might I suggest a recess to allow staff to set up for the presentation before we begin item 8?
All right. Certainly. This board will be in recess until 11:28. Okay, I'd like to call the meeting back to order, please. And we have for our consideration here, this is item number 8, presentation of the financial year 2009-10 tax and revenue anticipation note. And this is brought to us by the administration. Good morning, Shirley.
Good morning. Shirley Ryan, Assistant County Administrator. Here this morning with us is Jonathan Edwards and Rich Malone from Government Financial Strategies to do a presentation on tax and revenue anticipation notes, or a TRAN. And while the county's not unfamiliar with the TRAN, it's been a while since we've done one. In fact, I believe 2002 is the last year that we did a TRAN. And a TRAN helps manage cash flow issues. With counties, the majority of our revenue comes in with the first installment of property taxes in December. However, we have ongoing expenses all year long, starting in July. And over the past 7 years, we've been able to manage our cash flow through our cash carry and borrowing from other funds. However, that cash carry has gone from about $2 to $3 million to this past year it was $7 million that was repaid in April to those funds. Additionally, we used to borrow from the Solid Waste Fund, which has declined. In this current year, we borrowed from RIM and from the COP Fund. That, again, as I said, was repaid in April. So today what Jonathan and Rich are going to talk about is what it means to issue a TRAN, the process we go through to do so. And as part of that, what we were looking at and brought to the Debt Advisory Committee in April was, should we issue a TRAN, first of all? Would it make sense? And the conclusion that was arrived at, it would make sense if we prepaid our PERS employer contribution. This would, as opposed to the amount that was put in the agenda submittal, that was a very preliminary number that we had received. The actual number, as in Jonathan and Rich's presentation, you'll see is about $159,000 discount if we prepay PERS. Now that won't cover the whole cost of issuance and interest on a TRAN, but it will offset some of that cost and make this a viable option for issuing a TRAN as opposed to internal borrowing. Because as you know, as I explained last week, our cash carry this year is going to be minimal. And in years that we had $2 or $3 million to help us through, the borrowing from other funds was also less. With virtually no cash carry going into fiscal year 9-10, it really behooved us to look at other methods of handling our cash flow issues. So with that, I'll turn it over to Jonathan and Rich. And then afterwards, if you have any questions for them, for myself, for Lynn Norfolk and Linda Churches, we're all here and have worked on this in conjunction with the Government Financial Strategy.
So good morning, and thank you, Shirley. I think you did the first part of our presentation very well, so that's good. So we're here to talk about cash flow, and we have a little cartoon that hopefully will come up, and you can see the gentleman going to the loan department and saying, apparently there was an undertow in my cash flow. That's the situation the county may be in right now with cash flow.
Could you mind identifying yourself for the camera?
Sure. Rich Malone with Government Financial Strategies.
Thank you, Rich.
Okay. So the agenda for this morning, we're going to talk about the operating cash flow issues, which Shirley has already mentioned. Give an overview of tax and revenue anticipation notes, or TRANs. And then my esteemed colleague Jonathan is going to talk about sale methods or methods of selling TRANs, and talk about disclosure associated with selling TRANs. And then finally, we'll talk about the next steps. So really there's two drivers that are making us consider issuing TRANs for the 2009-10 fiscal year. The first is the fact that the county projects the temporary shortfall in cash based upon the timing of revenues and expenditures, again, as Shirley already commented on. And in the past, those shortfalls have been covered by internal internal funds, which may not be available in this fiscal year. And then second is the ability to prepay the contributions to PERS for the year, which will result in a discount of about $159,000. So substantial savings by paying that at approximately $4 million PERS amount. And so as a result of those two considerations, it makes sense for the county to consider issuing a trans for 2009-10 to cover, one, the prepayment of PERS, and two, the temporary cash flow shortfalls during the year. Okay. So what are trans? Tax and revenue anticipation notes. Short-term debt used to finance cash flow deficits in anticipation of receiving taxes or revenues. Authorized by Section 53850 of the Government Code. And under California law, trans are really the only method allowed for working capital operating fund borrowings in the public marketplace. Obviously, you can borrow funds internally, but if you want to go outside, you need to use a trans or short-term borrowing. Trans are very common. To give you some perspective, in 2008, so last fiscal year, approximately 300 California public agencies issued trans, totaling about $5.8 billion. And as Shirley mentioned, the county has issued trans in the past, most recently for the 2001-2002 fiscal year, and amounts have been around $5 million in the past. Okay, so how is the amount that you can borrow through a trans determined? Well, there are very specific guidelines, federal guidelines covering this. Basically, you can take the maximum size of the trans is equal to the largest projected negative cash balance plus a working capital reserve. The working capital reserve is the lesser of 5% of prior year expenditures or prior year's average cash balance. So you're going to take your projected deficit plus a reasonable reserve, add those two together, and you get your maximum trans amount. And then the projected cash flows for 09-10 must be based on reasonable assumptions. So you can't just make up some numbers and issue any type of trans you want. It has to be a reasonable amount. And so the exact size of the county's proposed trans is still being determined. We're still finalizing the projected cash flows, which will lead to the size of the trans to determine how much we're going to be able to borrow. Okay. So when must trans be repaid? Again, look at the Gov Code. 53854 says trans are payable either not later than the last day of the fiscal year in which it was issued, which would be June 30th, 2010 for the 2010 fiscal year, or in the following fiscal year only from revenue received or accrued during the fiscal year in which issued, not later than 15 months after the date of issue. And so basically that allows us to issue trans that are 15 months from date of issue. Practical considerations really limit trans to 13 months, but the marketplace really accepts 12 months trans. That's the most common time frame for a trans to be issued is 12 months. Right now, the proposed schedule has us closing the trans issue in early July, and so we would make the trans repayment due in early July of 2010, if my year is correct. So 12 months. I think that's it. Okay. So again, Jonathan's going to talk about sale methods.
Well, there's two basic methods for selling trans, and it's a similar discussion to one the board has had relative to issuing the Measure J bonds and the certificates of participation. The two basic methods are a competitive bid process, which is basically an auction involving underwriters, and then there's a negotiated sale process whereby an underwriter or lender, if you will, is pre-selected and interest rates are negotiated with that entity. As you can see, the county's borrowing policy does favor competitive sales when possible. Specifically, it says the county, as a matter of policy, will seek to issue its debt obligations through a competitive sale unless the debt advisory committee determines that such a method will not produce the best results for the county. Therefore, we do recommend that we plan on utilizing a competitive bid process to obtain the financing for this, but that we be prepared to pursue a negotiated sale should market conditions near the time of sale suggest that this would be a better option. As you know, the last 18 months in the financial markets has been pretty humbling. And although this is the type of financing that, as Rich mentioned, is common, and it wouldn't be at all uncommon for a county like Calaveras to engage in something like this, nevertheless, we do need to be prepared that at the time we go to sale, it may be a better option to identify a bank and really tell our story, so to speak, to get the best financing that way. So that is an option that we would like to keep open, but of course it's always our preference to use a competitive process if we think we can get bids. One of the items that will be in the board packet, if the board wishes to proceed and is asked to take board action on this, would be a document called the Preliminary Official Statement. Again, I know the board is familiar with this concept with regard to the Measure J bonds and the certificates of participation. This is an example of the front cover of the document. This is essentially the prospectus for the financing. A trans is a type of municipal bond, so in those respects, as in terms of an investment, it's just like our certificates of participation or the bonds that we issued, just a shorter-term borrowing with a different repayment source. But it's considered in a broad sense a municipal bond. So it would be publicly issued ultimately, and there does need to be a disclosure document, again, kind of like the prospectus for the financing. There's two basic purposes of disclosure. One is in that document we want to disclose all material facts so that we in fact can have honest and fair dealing with the markets, and also the document is used to market our financing both up front when we go to get the interest rates, and then subsequently by holders of the notes or the underwriter to remarket the debt in the secondary markets to the extent that occurs. It will be very important that the board review the disclosure as you have in the past, and as you may recall, the SEC, in the wake of the Orange County bankruptcy, stated that in authorizing the issuance of securities and related disclosure documents, a public official may not authorize the disclosure that the official knows to be false, nor may a public official authorize disclosure while recklessly disregarding facts that indicate there is a risk that the disclosure is misleading. So we certainly would ask that, as you have in the past, that you review that document. In terms of reviewing the disclosure, just some tips. Please remember the format is based on an industry standard for the convenience of the primary audience, which is investors. Standard information is provided in standard fashion, which is not often the best writing style, so it's not going to read like a John Grisham thriller or anything. But if you please stick with it, and maybe it's a good nighttime reading. Providing too much information, we have to be careful about that because that can obscure important points, but of course equally disastrous is omitting important information. If you have any questions after reviewing the document as to whether or not we should or should not include something, please bring that to staff's attention. They'll bring it to our attention and we can discuss it. So certainly better to err on the side of caution there should you have any questions or concerns and bring something up, and we can certainly discuss it thoroughly and see if it should be addressed. In terms of next steps, should the board wish to proceed at this time, on June 9th, the board would be asked to consider a resolution authorizing the issuance of the financing, the trans. On June 15th, final comments on the preliminary official statement or POS would be due. Again, the board could provide those to staff. They can pass those on to us. And we would plan to sell the trans on June 25th with closing scheduled for July 9th, which is before the PERS deadline for prepayment. And of course, as after July 1, we need to close after the beginning of the next fiscal year. So I'm happy to take any questions.
Supervisor Walensky.
According to this, we're saving $159,000 on the PERS transaction there. The offset costs for engaging in this, do you have any kind of inside-outside calculation for that?
Right, very good question. Let's assume, and it could be lower, but let's assume that we were to pay a 2% interest rate on this. On that particular amount of money that we're prepaying for the PERS portion, it's roughly $4 million, I believe. So that would be roughly $80,000 in interest costs attributable to that amount. So basically, there's still a benefit of roughly $80,000 at least, and that doesn't even take into account, that's not a strict financial analysis, because in addition to that net benefit, there would be the fact that instead of paying out incrementally monthly to PERS, we would hold on to that money now and be able to earn interest on it. So I think we can say that assuming an interest rate of 2%, and we can address that more, it could be lower, could be a little higher, but assuming that, we have a net benefit of at least $80,000.
Thank you.
Any other questions?
No, yes. I must not have been at the same debt advisory committee meeting. Truthfully, I didn't think we were going to do a trans. I thought we just, I'm missing something here. We talked about, even Mr. Edwards and I believe Mr. Arrow was with us, said that if we could do internal borrowing versus a trans, it's more cost savings to the county to do that. So I sort of am surprised that we're even considering a trans, since we do have we still have internal borrowing options, even though those funds are tight, unless we're wanting more than those combined funds can give us.
Supervisor Callaway, as I recall, and I thought in my discussion with the treasurer, tax collector, and the auditor, what the outcome of that meeting was yes, that it makes sense when possible to do the internal borrowing and when that was most cost effective. But if we could determine that issuing a TRAN would benefit the county, that we should look at that option. What prompted further discussion on this was when we went to repay the funds that were borrowed and the interest that was charged to the general fund for that internal borrowing, we went back and took further look at what the cost and what the benefits of issuing a TRAN was, and we brought forth that to the board today. And the cost of the general fund for the internal borrowing for that short period of time, for July through April, was just under $70,000. I think it was to the tune of about $67,000, but that also is an offset of money, interest lost to the general fund because the money was not in the general fund.
Well, I know the treasurer's been on us for years to put more money away, and every year we say, right, we hear you, and we don't do that. But we're not receiving even 2% on our funds. So, as Mr. Edwards said, if we go out and we can get 2%, that when we pay 2%, and on internal borrowing it's less than 2%, then why would we want to do? I guess I'm wanting to know why we even want to consider this, unless, I believe that we should prepay PERS, $159,000 significant. And we have huge expenses the first 6 months. We do our insurance payments and all in the first 6 months. We do all that up front. I am not clear why we're considering it. I think that's, I'm not saying no, Shirley. I'm just saying I think I'm surprised, because I thought even with the RIM or even solid waste, we're not going to spend it all within the next 12 months. We can go ahead.
Public Works has basically told us this year that they did not have the funds available in the solid waste funds to do the type of borrowing that we would need. In the RIM fund, the money is there to handle the cash flow issues. It's not, I do not believe it's there to handle a prepayment of PERS. And so, again, when we looked at it, we were trying to do a cost-benefit analysis. Is it to our advantage to get the savings or the discount from PERS of $159,000? Will that offset the cost along with having the money in the Treasury earning 1% versus going out and issuing a TRAN?
Could we do 159 from solid waste and the balance from the... I can see in 2 years... I'm sorry. apologize. I can see maybe in a year or 2 years we might want to do the trans, but if we can still afford to do internal borrowing this year, why we wouldn't want to do that? So I guess, can we negotiate with Robert? I mean, we just gave him money in the benefit basin.
The prepayment of PERS is almost $4.2 million. So if it wouldn't make sense to do a TRAN if we were not going to prepay the PERS.
Okay. So the prepaying of PERS, including, is the 4.2 is just for PERS?
That's correct.
And then there's the rest of the cash flow, and we still have insurance, the workers' comp, and all those upfront costs that we have every year. So how much more are we talking about? I know the exact size for the proposed trans still being determined, but are we talking somewhere between $4.2 and $8 million, and our internal borrowing will cover that?
And we will have those numbers for you if you choose to direct us to move forward and further investigate and bring this back to board on the 9th. We will have those numbers available. We have not, the auditor's office has not completed the cash flow issue, so we don't know the exact amount of the TRAN. Therefore, we don't know the exact amount of the issuance cost. And we'll be able to weigh that better on June 9th when we know what those numbers will be.
I guess for me, I'd like to...
It's $3.4 million worth of work that we have to come up with money to pay for. Am I correct?
I believe so.
Okay, I just want to... Well, no,
I'm
not running my calculator.
No, and I appreciate that, Mark. That's fine. I just want to get in the ballpark, and Supervisor Callaway, we understand that, but I also, we need, at some point, very, very soon, we need to have discussions. Where's that money coming from? Is if we're assuming it's going to come from the proceeds between AB 900 and Measure J, because these are expenses we would not have incurred but for the development of these projects, and that's the board's direction. I'm fine with that because we don't have the money in reserves. We may have access some amount from the RIM fee, but that's undetermined at this point.
Robert, you gave me that number. I thought you gave me a more or less precise number for the RIM fee contribution of $426,000. Is that right? Okay. So yeah, we do have an estimate.
Okay. So now we're down about $3 million.
Yeah.
Okay. So again, I want this board to be clear, because we're going to need to take $3 million out of that current project budget of $56 million, if that's my reading of what we're talking about here, to cover the immediate costs.
The COPSman. I thought that's part of what we did the COPSman for. Their COPs, excuse me.
The certificates of participation went for purchase, and we paid for. That's where the money went. We hit our max on the COPs.
And that's beyond. I mean, that's not.
The COPS money paid for the property. I don't know what the total COPS money available was, but
I think we have $5 million COPs, 5 or 6. Well, that's not what's before us today.
No, I understand, but I did not want to leave this discussion with people thinking we're talking about $474,000 in costs.
Oh, no. What we're saying, I just want to make sure. That's why I asked about the inflation factor being built in. So if the best guess estimate now is 245 plus or minus, then we have some room. So then the 500,000 cap makes it more acceptable. But that I don't want the AOJ thinking that we're saying 245. I want them knowing it's a $500,000 cap, and if they don't build, AOC, excuse me, if they don't build, we still want their money, and I want that part of it. I mean, if for some reason, because because of state financing, money is not available or delayed to build the court for whatever reason, we've built the roads, we're ready to occupy. They will reimburse us in 2011 or 2012 or whenever. Is that a true statement, Mr. Robert? Or do we have to wait for your building to get reimbursed?
That's correct, and it is also...
What's correct?
It is correct. It's correct that our funding comes in approximately a year.
So, but if for some reason the court isn't built, it's delayed, usually financial reasons, we do the work, we pay the money, and you're not ready to turn to it or occupy, will we receive the funds now versus when you then turn to it?
If our appropriation does not come through, then I don't know, frankly, where money would come to reimburse for a project that never occurred. I think that the point to, or one point I would like to make is that our fair share being 7% is a relatively small percentage of what is causing the upgrades in the road here, and I don't know. Honestly, is it a fair question whether or not a 7% decrease in participation affects the 93% that's still out there arguing for this change?
Well, wait a minute. I don't want to be watching a shell game here.
Yes,
we want to sign an agreement with you. I'm all for doing that, and I appreciate the work that council and your office have gone through. But things change. And if we're now going to start negotiating, well, we don't know we're going to be doing 7%. We're signing an agreement in good faith to give the courts a cap of 500, that when the work is done, we will receive that money. And unless council wants to tell me I'm missing.
No, I think that absent some other consideration, there's no justification for capping fair share. Fair share is fair share. So there has to be some other reason to motivate that. And there are some reasons here.
Well, that's what you said, Jim, is that we put a cap on it because that's what made it move through the courts.
Precisely.
And that's fine. I mean, I'll accept that. All I'm asking is if the jail doesn't go through, or it's postponed, it will go through, but it's postponed, we've done the work. At what point do we get then reimbursed? What we say today when we sign the agreement is their fair share. I don't want them saying, well, maybe it's not 7% and starting to whittle one here.
It's an excellent concession for you to get out of Mr. Roberts.
I'm happy to commit to whatever a fair analysis of those costs turn out to be at the end. And frankly, if it was determined that the costs that are described pretty clearly in the CEQA document, of which we are a committed partner to accomplish, if those costs were found to exceed, I think what I would, I can't create a budget right now to accommodate that.
We're willing to say there's a cap of 500. If the fair share is 600, the county's willing somewhere to absorb the extra 100. So if we're putting a cap on it, we understand. If the fair share turns out to be 300, then that's all the state will reimburse the county. Am I correct on that? But that's the fair share.
Janice has something to add that's pertinent here.
Janice Elliott, County Council's Office. The way I've treated this project from day one is just like any other development project. We're a developer, they're a developer. Everything's set up exactly like any other project. In this case, the mitigation measures in the mitigated neg deck require the project proponent, who's ever up first, or here hopefully together, to do the off-site improvements, which are going to be supplemental improvements like we talked about earlier, similar to Mr. Couch. our fair share and their fair share. We're going to pay our fair share and seek reimbursement from all other funding sources for the majority of the cost. Some of it will be in the San Andreas benefit basin, some of it will probably be in the, well, we're not sure yet, the RIM fee, and there are other funding sources available also. When we seek reimbursement for supplemental improvements, we enter into a reimbursement agreement, which is really the next step with the AOC. Generally speaking, the reimbursement is triggered by the reimbursement agreement, and the latest it's usually triggered by is prior to certificate of occupancy, meaning they don't get to occupy until they pay the fair share. Here, the only thing that's different that you're doing here is you're putting a cap on it, which is a negotiable part of the agreement. I think staff is pretty comfortable that what you've been given is worst case scenario, and it actually potentially may go down, although our goal is to not reopen the environmental document for various reasons. So the question you asked initially, though, is what happens if the jail never gets built? Technically speaking, if the jail never gets built, these improvements are triggered primarily by the general plan requirement that we bring this road up to a level of service C. It's currently level service D. The fair share portions of the road improvements are fairly minuscule, and that they're 7% under the CEQA document. So I would suspect, and I'll defer to Robert, that if the jail never got built and approximately 7% of the impact went away, we'd still need these road improvements at the current level that they're being proposed, and we would just shift the reimbursement.
I hear the word. I keep hearing the word jail. Do we mean court, or do we really mean jail? Court.
I'm sorry, did I misspeak? If I
misspoke. Because Marina mentioned, I just want to make sure we were all on the same page.
Okay.
Followed her down the path.
Our Janice, if it gets built 3 years or 4 years.
Whenever it gets built, the reimbursement agreement will specify when they are required to reimburse us. Under normal development, it's prior to certificate of occupancy or prior to issuance of a building permit or something similar like that. You're free to negotiate it here if you'd like, but what I'm saying is if the court never gets built, we will probably shift that fair share reimbursement over to the other funding sources.
So I guess what I'm asking then, the court moves out 3 years beyond whatever. But we've expended the money for their fair share today. And they're going to pay us back whenever they turn dirt or they open the door. That's in that agreement that you work with them. Can it not be when we finish the project, they pay us then? Or do we have to wait until they turn dirt to get reimbursed?
Well, all I'm saying is that under general development principles, if they never build, they don't have a fair share of impact.
I understand.
So if we can trigger it at any point in time, I would suspect an appropriate date, if you are concerned about this, would be at construction start date, which is earlier than we normally require. But that would mean they're committed, they have the funds to do the construction, and at that point in time, the roads should be in place.
Jensen, I think just interject. It seems to me that the CEQA requires that the roadways be complete after all construction is construction traffic certainly is done, and so it sort of implies that these improvements can take place towards the end of construction.
It'll be helpful if you're up here on the mic because it's being broadcast.
Right. The point was that my reading of the CEQA was that it seemed to require that those improvements be made towards the tail end of construction to minimize wear and tear on the cruiser lane.
That works well if we're on the same schedule. What I'm hearing Supervisor Callaway say is, what if we build the jail and the court is not there? When then are your reimbursement costs kick in? And I would say at that point in time it would be construction start date, because we have to build the roads to open the jail. They have to be there. Generally speaking, if we run into this type of situation, what we've done in the past with developers is required bonding for any construction impacts to the roads, etc. So that is a contingency that we'll have to address in the reimbursement agreement. We're all hoping that doesn't happen, obviously, and that we're all on the same construction schedule. The other could happen, meaning they build and we haven't built yet. And so that's another alternative too, where we'll have construction traffic going on an already built road. But there's nothing we can do about that. Our goal is to just acknowledge all those contingencies and address them in a reimbursement agreement. But hopefully we'll be on the same schedule because there's an economy of scale to the construction costs, and we've addressed that too, potentially, like grading, etc. But normally it's certificate of occupancy or building permit issuance that we put into the reimbursement agreement.
I have a question after Bob.
Oh, thank you. Just very, very quickly, this is also in the context of a larger agreement. It's an exchange of interest in property. So we're going to exchange the interest in the parcel on the hill for the rest of the courthouse, in effect. If this project, for whatever reason, we're talking about the possibility that the courthouse not is delayed but isn't built, and how do we recover the cost that we put out? What happens to the ownership of these respective properties? If the courthouse is never built or the project is postponed indefinitely, the AOC will still own the 7-acre parcel. Am I correct about that, or will it revert to the county?
I'm not sure that we covered that contingency in the agreement, and clearly we should.
Because I'm just saying, because Marita brought up the notion that what happens if it isn't built? Because you'd have a piece of property up there that you're not doing anything with. The courts would be operating in a property where the interest is now going back to the county. Then do we have an issue of, can we recover the cost of some kind of mutually agreeable rental agreement for occupying the property in lieu of having built and vacated? I mean, Marita, that's what I'm trying to get to with, we got a development issue over here, but we also have a real property issue, too, at the same time. And maybe that's the way we solve. If there's a question about the development, maybe we solve it to the real property end.
I'm not sure. Would the same consideration be applied to, say, Kaiser, who's got a 18,000 square foot expansion that's being planned? I think that's one of the contributors to the need for road improvements. I mean, Kaiser. If a project is not,
You've got the wrong county.
Yeah.
I'm sorry. Which the hospital down the road here?
Mark Twain.
Mark Twain, St. Joseph. Okay. Sorry. I'll find that it's listed in the secret document. But there's an 18,000 square foot. But 450 dwelling units that were scheduled. I think these are all a list in the secret document of contributors to the traffic load. And I don't know what guarantee the county really has that a future project in the pipeline, as it's described in the secret document, is actually going to be a real contributor.
I have a second question.
No. It seems that contingency.
I think you're complicating the question. The question is if something falls apart, you won't want the court space here, you won't want 7 acres up on the hill, and we need to...
I don't want to interrupt, but as I recall, I don't have the document in front of me, but I do recall at least in one draft there was reversionary.
Okay, then we have taken care of it.
I believe it's in there, actually.
If it's not in there, we should...
Yeah, I'm pretty sure it's covered somewhere in that document. I just haven't looked at it in about a week.
I have one more question. I don't want to beat this up anymore. I just want to make sure we get their money. I'm going under the assumption that the court will be built. In the reimbursement agreement, which comes after this, it's a separate agreement. Yes, I would like to see that the state reimburses at start of construction. That's my take.
All right, well, we'll obviously have to, we haven't even begun negotiations on that, but...
They're not going to start or be working at the same time we are. And they might, for whatever reason, Mr. Roberts said, they won't know till next year about their funding. Then I would want, if they're a few years out after the jail, then I would want it at Because they're going to be paying us in future dollars when we're expending it in today's time.
Right. Well, if everything works well and we construct at the same time, the actual improvements will not be done until everybody's done with the construction traffic. So we can accommodate all that.
I mentioned earlier we've made a variety of concessions. We've advanced $200,000 on behalf of the state. A little ironic, but we've advanced that money to make this thing go. So in terms of the merits of the positions, I think we should be able to convince Lee that we want to have that reimbursement come in at the earlier point.
Okay, another clarification, change subject. On the infrastructure, water, sewer, did I understand you to say that we pay for our needs and the courts pay to oversize it for their needs?
That's correct.
Okay, thank you.
One could argue that we would divide that cost 50 on some other basis, but early on we made the concession that we're putting a sewer line in for the jail, and so that's on us. If it has to be larger because of their added burden, then they pay for that.
There are a lot of concessions.
There are a lot of concessions, but that's what I take from the board's desire.
I just have one other comment so that there's no misunderstandings here about this diagram. This is not the on-site roads that you saw in the mitigated negative declaration. This was prepared because we wanted to ensure that since we paid a substantial amount of money for this property, that somewhere down the line, if the county decided to further develop the property with additional CEQA review, that we wouldn't build something now that would cut off circulation in the future. So this is a document. I don't want the public to misunderstand that this is what we are going to build. This was just looking at long-term circulation so that we don't give something away that we have to go acquire back in the future when we need a right-of-way to hook up for additional use of the property. But right now we're restricted in our use of the property by the CEQA document that we've currently approved.
And we're only talking about the area in blue. It's outlined in blue with the exception of Government Center Road going up to a point. Is that correct?
The area in blue for the road improvements?
Yes, road improvements.
That are required as part of the project that's in front of you now, yes. So any additional use of the property would require additional CEQA review, and that's when we would look at all of these alternative alignments. We just didn't want someone to plop a building right where we might want to put a road in the future.
Okay, I want to ask one question that hasn't been specifically stated, but this phrase that says the county to advance $200,000 toward the sanitary services for the court facility. There is part and parcel of that is we would get reimbursed that $200,000.
Yes. In fact, that money's already been advanced.
All right. Okay. Now the only major problem I see with this map that you handed out, Mark, is that a portion of this road, that first road going in there, it exceeds 16% grade, so it's not a legal road. So.
Correct.
Construction standard.
Right. It can be worked around.
Okay.
These are straight shots. This is a very short, quick look at what we could possibly do.
Okay. Have to have four-wheel drive to get up that road. All right. This is a possible action to grant tentative approval for this agreement. I guess, yeah. Judge Manwini, did you have some comments to make here?
Just briefly. I just wanted to thank the board and Jim for this has been a cooperative agreement, and I appreciate it. We're trying to coordinate this with the jail so construction occurs at the same time, and it wasn't particularly by design, but by happenstance that seems to be working out. It's important that we move forward only in that the State Public Works Board as Lee mentioned, we're in actually, beginning July 1, we'll be actually in the third year of what was to be a one-year process of acquiring the property. And it's been very It's been fun. But we've changed from the library site to this site because we want to coordinate. We want to not have jail transportation costs and all those things. So I appreciate what the board is doing. I appreciate the concessions. The AOC has made some too. We're trying to put this project together, and I appreciate your efforts to do that. That's all I wanted to say.
Thank you, Your Honor. Okay, anyone in the audience wishing to comment on this item? Okay, I think a motion is in order on this tentative approval.
I move a minute order. Bring to the terms of, I mean, there's nothing.
I'd settle for some board direction, unless Lee, do you want something more formal from this board to take to the?
No, I think that tentative approval is everything that we need. It's
with a cap of $500,000.
Yes, and that's for the term of the entire agreement.
So, sure, a minute order is fine. We'll draft it so it's clear that it's tentative only.
Okay.
Okay, and that can be accomplished just on her say-so, huh?
I am. It's my major minute order.
That's what she tells me all the time.
It's just a minute order. It's just giving. I mean, you don't even need a formal minute order.
I think we need direction, which would be based on the poll. But the minute order will document this conversation.
The minute order will document the general terms of the agreement, and if there's any changes, it will come back to the board.
It will. It'll come back to the board.
Either way, it comes back.
Either way, it comes back for a final.
Yeah. So is there a second?
I'll second that.
Oh, major? Yes.
Okay, moved and seconded for the minute order. All in favor say aye.
Aye.
Aye. Opposed? There are none, so that item is approved. Thank you very much. Okay.
Okay. You want me to drop them back?
There's nothing confidential.
You keep them.
Okay.
I'll just hold on to yours for you.
Pile it up.
If you want to keep it, keep it.
So we can get through correspondence.
Yes, could we keep focused here long enough to get the correspondence done? Supervisor Tryon, do you have anything to report?
The only item I have to bring before the board is we did have another fatality on Murphy's-Grade Road over the weekend.
A motorcycle.
And another motorcyclist. So, I guess we'll get another lawsuit out of that, I suppose. But, to just bring that to the board's attention. That's all I have, Mr. Chair.
Okay, Supervisor Walensky.
Sometime tonight I'll get to Washington, D.C. I'll be meeting with 6 congressional offices, 2 senators' offices, the USDA Deputy Undersecretary, and the U.S. Forest Service Chief. Actually, probably the head of that, as well as the Deputy Chief. And on Monday, I'll be in West Point delivering the annual Memorial Day speech.
Well, according to that schedule, you're going to miss the Board of Realtors meeting on Wednesday.
Yes, I will probably be missing that.
Okay. Supervisor Tofanelli.
I have nothing to report.
Oh, boy, Gary.
I have the Solid Waste Committee tonight. I'll be going to Parks and Rec Wednesday.
Tell about Murphy's. Tell her that you want to be.
And that's it. I can't talk anymore.
She's lost her voice.
What? You got this on film?
Couldn't you have done that retroactively on the past agenda?
One more item. Tom, I need to remind you again, you're doing fishing days for me on the 27th.
Oh, God. 27th.
Yes, it's a Wednesday. Thank you, Rex.
That's a week from this Wednesday.
It's a Wednesday.
What time?
Tom, I've emailed you, I've told you, Rogers called you.
Okay. I'm not sure I can do it, but I'll try.
And when is the juvenile justice? Is that 4 or 5?
That's at 5 at the probation office on the 28th. Thank you.
Okay. I see on here, just a reminder that there is, that we've discussed this a number of times, the Jim Frost retirement dinner on the 22nd, Friday night, the 22nd. Okay, and that's all that I have to report. So, Mr. Lawton?
Mr. Chair, hopefully this will become general news late enough for most people not to have been able to get there, but I will be appearing at the Murphy's Community Club this evening at the Native Daughters Hall in Murphy's. So wake the neighbors, tell the kids. And I'll be discussing the county's financial situation and our prospects for the future. And I will be bringing a collection box. So I do look forward to visiting with the good folks Murphy's. They were wonderful hosts last year, and I hope to leave intact tonight. So yield the balance of my time to the distinguished county council.
Mr. Jones?
Nothing further. Nothing to add.
I have one thing to add. I wanted to say congratulations to Kayla Smith, Ms. Calaveras from Valley Springs, 2nd year in a row. Congratulations.
All right. Carol, do you have anything to... All right. I think that concludes the business here. We are going into closed session on an item having to do with litigation. So thanks for coming. We'll see you next week.